To set the table for today's intellectual feast, we are going to start with an intellectual as well as historic giant, attorney Thomas N. Todd. Thank you very much, ladies and gentlemen.
You take this and bring it to me when I finish.
I will. Do you want the stool here?
Freedom, oh freedom. Before I'd be a slave, I'd be buried in my grave and go home to my God and be free. I woke up this morning, my mind stayed on freedom. Oh, I wish I knew how it would feel to be free. I wish I could break these chains holding me. Oh, but Langston Hughes teaches that freedom is just frosting on somebody else's cake. And so it must be till we learn to bake. I am pleased and honored to be here with these distinguished panelists and this distinguished staff at the distinguished DuSable Museum. It's an oasis in a desert, and it's always a pleasure being here. When I look at where we are as a nation, when I look at what is going on, I realize that we must know the past so that we can understand the present and plan for the future. Know the past so that we can understand the present and plan for the future. And so we are here during Black History Month. In 1926, Carter G. Woodson realized that American history was not the history of Black Americans, but there were so many distortions and lies until we call American history his story, but not our story. And so in 1926, he founded Negro History Week to just talk about some of the things that and some of the contributions that blacks have made, because they were omitted from the larger picture. And so he talked about how can you omit from not only the nation, but also the world. And that's why, although we celebrate Black History 1 month, Black history is every day and every week and every month, 365 days a year. How can you not celebrate the contribution of people who contributed words like okay, and who worked with yams and okra and gumbo and tote and goobas and hoodoo and mojo and and How can you omit that? How can you not deal with that in your history? How can you not deal with the history of people who invented the golf tee, the curtain rod, the ironing board, the fountain pen, the egg beater, the dustpan, the gas mask, who pioneered revolutionizing sugar refining, who pioneered in developing the process for preserving blood plasma? How can you omit that? And so we now, over and over again, every month, every year we come on this time to deal with talking about those contributions and finding out where we are, because as we know, no building can stand without a foundation, and no tree can stand without its roots, and no people can live without a knowledge of their history. I listen to commentators now talk about America being a country of immigrants. Well, black people didn't come to America through Ellis Island with cardboard suitcases yearning to be free. We came through the Middle Passage, kidnapped and sold into slavery. I know you're looking at me and saying, well, he's turning those pages in that notebook. He's old-timey and old-fashioned. You're right. I'm still walking on the dirt road while you're on the information superhighway. But let me say this to you. I don't care how sophisticated your computer is. I don't care how smart your smartphone is. I don't care how much technology you have. You still can't download freedom. I want you to understand that. No, it's okay. So you've got to be free. You've got to work. And so here we are now in 2015, living in what I call a racial twilight zone. Living somewhere between freedom and slavery, living somewhere between servitude and liberation, going around and around and around, confusing movement with progress. We're still not free, and that's what we must understand, and we must understand it over and over again. Black people brought here in 1619, before the Mayflower, all of us were not slaves. It wasn't until the 1600s that Maryland and Virginia decided to strip black people of their rights. They stripped them of their rights, can't serve on juries, could not testify in courts, could not own property. And so we look at the sequence. In 1857, Roger B. Taney, Supreme Court Justice, declared in Dred Scott that blacks were not human, that they were not persons, that they were not citizens, that they had no rights which a white man was bound to respect. Don't look at me funny, I didn't write this history, but I'm so glad I know how to read it. And so from 1857, we go to the Emancipation Proclamation in 1863, where a few blacks were turned loose in areas where they were in rebellion against the federal government. Not all blacks. And that wasn't freedom, it was emancipation. How can you be free if you don't have the right to vote? How can you be free if you don't have the right to an education? How can you be free if you don't have 40 acres and a mule? So that was an emancipation. And so after that, it didn't work. The states enacted what they called the Black Codes. And the Black Codes of South Carolina and Georgia and Alabama put blacks almost back in formal slavery. And so then in 1865, the 13th Amendment, 150 years ago, was enacted. And the most important part of the 13th Amendment is Section 2, which gives the Congress the authority to enact statutes. And so they began to enact statutes, 1866, 1870, 1875, 1957, 1960, 1964, 1965, 1968, all of these to confer human and civil rights on black people. No other group in this nation and the history of this nation has ever had to go through the initial obstacle of establishing being human before you deal with civil rights. And so we look at them attempting to convey human status to blacks. It didn't work. And the question now is whether or not Dred Scott still lives. The question now is whether or not black people who were created civilly by laws, conferring upon them human status, quote, close quote, as well as conferring upon them civil rights. If you take away the rights, then you can give them, and if you give them, you can take them away again. And so with all of the enactment of statutes, well, Abraham Lincoln freed the slave. Abraham Lincoln was a white supremacist, believed in the superiority of the white race. Read his 1858 debates, where he indicated that he, like any other white man, believed that there should be a superior and an inferior race, and as long as he's there, the superior race should be white. Why am I talking about this in 2015? Because it hasn't changed. The more things change, the more they stay the same. We're still overcharged and shortchanged. Always count to change. And always beware of old snakes in new skin. If you needed the 1865 13th Amendment to abolish slavery, why did you need the 14th Amendment in 1868? If you had the 1868 Amendment, the 14th Amendment, why did you need the right to vote in 1870 by federal statute? And if you got the right to vote in 1870, why did you need the 1965 Voter Rights Act? It is the okey-doke, a hoax, and we're still grappling with the initial designation by Roger B. Taney that we are less than human. Oh, you're overstating the case, Todd. Well, maybe I am. But we hear all of this mess about racism this, racism that, but they don't define racism. Racism for me is the belief in the inherent inferiority of one race over another. The inherent. And even in Brown versus Board of Education, the judges said that if it's all black, it is inherently unequal. Inherently. Meaning, of course, that you cannot change that if it's a part of your overall makeup. And so we said, we look at the cases that are happening now. We look at Ferguson. We look at New York. We look at Sanford, Florida. And we say, well, why is it that the local people did not indict? Why didn't the federal government indict? The federal government knew that it could not meet the federal standards to indict. And so all of this hullabaloo about federal indictment after the state failed was nothing but that hullabaloo. It's been 3 years since Trayvon Martin. No indictment. And there won't be an indictment in Trayvon Martin from the federal government because they knew from the beginning that you must act under color of law. George Zimmerman was not under color of law. He was a citizen. He was not a police officer. They knew they weren't going to get an indictment in Ferguson because the statute dealing with the deprivation of civil rights is an 1866 statute. Hasn't been changed. We've got all these people in Congress and all these people elected. We still have not changed that statute substantially. To get a federal conviction or indictment in a civil rights deprivation case, you must first determine that the person is acting under color of law and that they willfully and intentionally decided to not kill a person, but to take their civil rights without due process of law. And so today we are going to answer those questions. I ask you the questions and you may ask them back to me. Does Dred Scott still live? Is the 13th Amendment still being violated? Are we fully free? Have we really reached that point where we are accepted as equals? Dr. Martin Luther King Jr. in his Free at Last speech, you call it, I Have a Dream. In his speech, he used the words equal and equality he used the words freedom and free 22 times. He used the words equal and equality too. Have we arrived? Are we there yet? That's why we're here today. Thank you, Brother Cheatham. Thank you, DuSable Museum. And thank you, staff members. And thank you, panelists, for all that we do and all that you're doing. And let's get it on.
Ultimately, the reason why we're here today is because we understand that before we can have the outrage for Ferguson, before we can have the outrage for what took place in Money, Mississippi in 1955, before we can have the outrage of what took place in 1965 with regards to Selma, as well as the outrage we will have tomorrow because of the injustice that was done to the film Selma, we had to come to the point of origin. What took place first? Freedom, or so-called freedom. That is what we hope that today's program will explore and analyze. Next point. Has anyone ever had an intellectual butt whipping? Raise your hand. I'm sorry, that's the way to do it. Intellectual butt whipping. You came to a gunfight with a knife. I use that well-worn example before I bring up our moderator for today's program. I got the best, most influential intellectual butt whipping from Dr. Charles R. Branham right here at the DuSable Museum, because I brought opinions and conjecture to a fact-based debate. And that is the strength of our moderator for today, because he will not allow you, your foibles, to bring something half-hearted, and this is why he is the moderator for today's program. Ladies and gentlemen, historian for the DuSable Museum, as well as the University of Chicago, Dr. Charles R. Branham.
Does anybody feel what I feel after hearing Todd talk? How many of you know your invisible man? How many of you have been Ralph Ellisonized? You know the story of Mr. Trueblood. Notice that name, True Blood. And you know he represents the crisis as well as the triumph of the African American experience. And remember the remark that was made as they went out into the woods, and the young person turned to him and said, "You have looked upon chaos and are not destroyed?" And Mr. Trueblood turns and says, "Nah, I feel all right." That's the way I feel about this discussion of the 13th Amendment. African Americans have looked upon chaos, and we have not been destroyed. But we're not unmindful of the struggle that continues. Freedom isn't free. It has to be guarded vigilantly. This discussion is not about the past, about the evolution of the 13th Amendment. It's about the way in which the 13th Amendment affects our lives today, but also hopefully it'll be prescriptive. That is to say, we'll also discuss strategies that people can employ to reanalyze the ways in which the 13th Amendment may be used in the future to advance our civil rights. In that regard, I have with me on the panel the extraordinary historian, Dr. Christopher Reed. And I'd like to ask Dr. Christopher Reed to come forward and join the panel. My job is not to get in the way. Oh, I'm sorry. Okay, our third discussant has arrived.
I think they want you over there.
I have not had the pleasure of meeting our third presenter, but she has an extraordinary background as the Chief Executive Officer of ACE Municipal Partners, a full-service municipal consulting firm that works with small and mid-sized cities in the Chicago and Northwest Indiana area. So would you please give a round of applause to Amara Emiya. Welcome, we're very happy to have you. Please have a seat. As I said before, we're going to start off with a little brief historical background for our discussion of the 13th Amendment. So I'm going to join our panelists and let the discussion begin.
I want to congratulate the DuSable planners for giving us a historical, can you hear me?
Good. I took the mic away from Christopher Reed. Before he begins to talk, I think you should know who he is. He is perhaps the foremost African-American historian in the city of Chicago, one of the foremost African-American historians in the country. Nobody knows more about African-American experience in Chicago than Dr. Reed. For years, he was the chairman of the Department of African-American Studies at Roosevelt University. He is emeritus. And now, Professor Reed, now that he's had his propers, can begin.
Thank you.
Is that working? Is the mic working?
One correction, nobody knows everything about the African American experience in Chicago. No one knows more than anyone else about that experience. It's too complicated, too complex, too many nuances to lay claim to knowing even a small portion of what has transpired in the city. I don't want to stay on that theme, but I do have to mention that, mention one example. For example, if you, I grew up on the west side of Chicago, but I was born in what is now called Bronzeville. I know nothing about Woodlawn, although I lived there shortly. I know very little about Chatham, although I lived there shortly. We had dozens of high schools when I graduated, many more now, but I don't know what happened at Harlan High School or what happened out at Lindblom in the 50s, 60s, 70s. No one knows everything about this complicated, complex, nuanced history. We're still learning it. And all credit to DuSable Museum for having panels and events such as this to inform us about this history. I want to talk very briefly about the historical background to the 13th Amendment. And I have to say, as Charles Branham said, there's a reason they call this gentleman to our far left Attorney Todd, or as he's known, TNT. That was a TNT presentation. All thanks to the DuSable for giving us a brief historical synopsis of this amendment on page 3 of your program. And this is worth studying after you leave here. Let me talk about some of the things mentioned here and introduce you, though, to other dimensions of this story. The 13th Amendment, as first proposed, and it's mentioned here in this writing, seemed to have been a pact with the devil, because the first instance as to when there was going to be an additional amendment to the Constitution came about when Southerners were saying, we're going to leave the Union unless you do something that satisfies our fears. And the gesture from the political leadership in Washington, from the Congress, was to propose having a new amendment. For the first time in over 50 years, there'd be another amendment to the Constitution. That was supposed to have been the 13th Amendment in early 1861. It would have forbade federal interference with slavery in any state that had the institution of slavery. Before that could get going, and only 2 states ratified that amendment, Maryland and Ohio, and I don't know why Ohio did it. The war came, and with it, circumstances that were going to lead to another 13th Amendment. Now, the second time the 13th Amendment came up, this was a pact with angels. The hand of the Lord must have been involved, because this was an amendment to end slavery once and for all. And that was great. You may have seen the movie Lincoln. You'll notice there was a lot of scrambling around to get the amendment passed by the Congress, and then it would move on to the states, where 3/4 of the states would have to pass on it, and then it would be added to the Constitution, which it was in December of 1865. That scrambling around was interesting. You would have seen that a whole lot of people might or might not have been in favor of emancipating 4 million persons held in bondage. A political deal was struck just so freedom could flow. I'm glad for it. I didn't like the maneuverings, the machinations to get it passed, but that was good. The promise of freedom came. Keep in mind, though, there was pressure to have something done, whether it was the 13th Amendment or an executive order such as the Emancipation Proclamation had been back in 1863. Something had to be done to satisfy the stirrings among 4 million African Americans. Now, some of you probably read or know about Dr. Du Bois's book from 1935, Black Reconstruction. What's important in that book for our discussion today is that he talked about the restlessness, deliberate and then sometimes coincidental, among the 4 million who were enslaved. The slaves stopped working at the level they had been working when the masters were around with guns at their heads. That makes sense, doesn't it? Du Bois referred to it as the general strike. This hindered Southern food production and worried Confederate leaders, because most of the men were away fighting Union armies in the Western and the Eastern theaters of battle. And I guess I'd be remiss if I didn't mention that my great-grandfather, as is mentioned in this program here, by 1864, was over in the Eastern Theater with thousands of other black troops fighting against the Confederates. By 1864, there were a large number of African-American men who formerly had been enslaved, wearing blue uniforms, trained to fight, taking on the authority of a man, because, and I hate to say this, and I hope I'm not misunderstood, but I've got a lawyer over here to protect me. In that uniform and with that weapon, you had the authority to kill. That was a big deal, because for generations you had no authority to do anything, not even what? Control your own labor, the fruits of your own labor, the goings and comings in your family life. But now you could what? Kill. Very important. Anyway, what I'm saying is that there were pressures to have this second 13th Amendment brought up. Pressures from the African community itself. And finally, as I mentioned before, in December 1865, 3/4 of the state had done what they needed to do after the Senate and the Congress had done what they should have done, and freedom came. Now, the expectations, point number 2, about this freedom under the 13th Amendment. This did not guarantee citizenship rights. That wasn't going to come until the 14th Amendment was passed by both houses of Congress and ratified by 3/4 of the states. That didn't occur until 1868. So between December of 1865 and late 1868, in effect, black people were in limbo. This is one of the themes that Attorney Todd has brought out earlier, living in limbo. My folks were living in limbo. You had freedom, but freedom to do what? Well, blacks, being the go-getters that they've always been, started doing many, many things on their own behalf, such as what? Marrying.
Yep.
Flock of people wanted to get married before their ministers. It would be open and above board. Owning land they had worked for generations. Setting up schools. Yes, they only had nickels and dimes, but that generation coming out of the bondage, years of bondage, knew what to do with nickels and dimes. Many of you just leave nickels and dimes on the counters of stores saying, oh, I can't be worried with 3 pennies. And you leave it there. Of course, if I see those 3, I'm smart enough to take it. You know the story, building schools, building churches, doing for self. That's the story you don't hear about during this period of limbo. The period when the 13th Amendment that guaranteed there would no longer be slavery didn't guarantee too much else. And by the way, during the period of limbo, 1865 through 1868, policemen aiding and abetting mobs of anti-black people killed, burned, wounded, threatened black people with impunity. It was open season. Then finally, the 14th Amendment was ratified and citizenship came with the very important second section that said there should be due process and protection of the rights of citizens under the due process phrase. Attorney Todd has mentioned that within 2 years there was federal protection of the right to vote. By the way, the interesting thing about that 14th Amendment, it in fact gave citizenship rights, and the states then had blacks voting in the South. If you lived in Illinois, by the way, in 1868, you still could not vote. In 1869, when blacks in the South were voting, you still could not vote. By 1870, when it was necessary for the Republican Party to protect its strength nationally, the 15th Amendment came along. The federal government said, we'll protect the rights of these blacks who are already voting for the Republican Party because we want to stay in power in those states, which gives us a national claim to political leadership in this country. By the way, by that time, Illinois was willing to allow blacks living here in Chicago the right to vote. So as not to confuse anybody, the states are the only bodies that confer voting rights. The federal government in the 15th Amendment only protected people from the abuse of states and state agencies from interfering with your right to vote. So in Illinois, so as not to be embarrassed as the state ratified the 15th Amendment, the General Assembly said, we will extend the franchise, the vote, to all of our colored male citizens. If that isn't trichology, I don't know what is trichology.
It's called the okey-doke.
The okey-doke. I'm going to find out what that word means after this. I heard President Obama mention that word, and I wonder where he got
Don't worry,
it.
he doesn't know what it means either.
I know.
But I have a definition of it. I'll give it to you, probably.
No, I used to use that word, and I heard Denzel use it. All right, I want to conclude by saying that once the 13th, 14th, and 15th Amendments were added to the Constitution, there was a semblance of improvement in the lives of African Americans. So the go-getters had 3 steps upon which to stand to do even some of the greater things they were about to do, like setting up colleges, like setting up businesses. Why, we even had a woman, mind you, down in Virginia who set up a bank. That the women are supposed to smile. Yeah, Mrs. Washington, wasn't it, Brandon, down in Virginia?
Yes.
I think her name was yeah. Yeah, we set up banks. We had businesses throughout the South. And we continued to fight oppression and domestic aggression and move ahead and continued to vote. And we had 2 men in the Senate way back when. We had 22 men in the, over an extended period in the House of Representatives. We had sheriffs. We had justices of the peace. We had a man in the South Carolina Supreme Court. We started to make headway, all under the threat of the gun. But because of the 13th Amendment, followed by the 14th Amendment, a certain amount, a semblance of some protection. Let me end on this note about the 13th. That's a semblance of protection because by the 1900s, those who had previously been slaves before there was a 13th Amendment now found themselves working under a system called peonage, P-E-O-N-A-G-E, peonage. You were a peon. So legally you weren't a slave after December 1865, but in actuality, in the 3-4 decades that followed, leading down to the 1900s, too many black people were reduced to the level of being peons. And you usually associate that with plantation, debt slavery, and probably related to the use of convict labor. And you know that story all too well. Accuse somebody of doing something wrong, from not having money in his pocket. That's what my wife does to me. I'm winding up. Okay. Yeah, so peonage unfortunately became a fact of life. Peonage ended legally within a decade or so after that, and yet, yesterday when I was at a conference that SNCC sponsored on Selma, there were people outside of Selma, Alabama in the 1960s living in virtual slavery and being paid once a year, not in American currency and paper, but in script, S-C-R-I-P, a piece of paper that someone on the plantation said, this is worth $10 at the general store, signed Mr. Jim. So let me conclude on this brief exploration of the 13th Amendment and how it affected black life and the other 2 amendments leading into, well, virtually nowhere, unfortunately, by saying thank you for being observant, attentive, and here.
Okay, I think that we should ask Attorney Tom Todd to discuss the legal implications of the 13th Amendment. And one of the first questions that I hope he will respond to is, why is it so seldom used or litigated?
Well, first of all, is my mic working? I have a level mic. First of all, when you look at the Dred Scott decision, and I use the Dred Scott decision deliberately, because Roger B. Taney took an opportunity in dictum to really use the Supreme Court and the laws of the land to affirm the less than human status, allegedly, of black people. in the United States Constitution, the only place that blacks are mentioned, Article 1, Section 3. And in Article 1, Section 3, blacks are considered to be 3/5 of a person added to those persons who are free for apportionment and taxation. And so as a result of that, Roger B. Taney in 1857 made it very clear that when the words persons and citizens were used in the Declaration of Independence in 1776, when they were used in the Constitution of the United States in 1789, they did not refer to black people. One of the most difficult things I have ever been able to deal with is to get people to wrap their minds around the fact that just 158 years ago, blacks were considered like beasts of burden. They were considered the same as oxen, as cattle, as horses, as mules. Now that's hard to accept now, since you can do all the things that you do, that you think you can do, but that was 158 years ago. And the status was all done by laws, by the enacting of laws to strip blacks of any kind of rights. One of the first laws was passed. It was against the law to teach slaves to read and write. Education was considered dangerous. And Frederick Douglass's mistress was teaching him to read and write. The master said, do not teach a slave to read. The next thing you'll know, he'll want to write. The next thing you'll know, he'll want to be free. So that education and freedom have always been. And so what you do now is that after the 13th Amendment, you pass the 1866 Civil Rights Act. And then that didn't do it. And some of the statutes we're using now still 1866. Then the 1870 Civil Rights Act. Then the 1957 Civil Rights Act. Then the 1964 Civil Rights Act. Then the 1965 Civil Rights Act. Then the 1968 Civil Rights Act. All of these acts trying to confer upon black people what white people get by being born. So that not only did the 13th Amendment didn't work for us, but the 14th Amendment didn't. And not only did the 14th Amendment work for us, the 15th Amendment did not also. Because in 1960, the 15th Amendment was 1870, in 1960, I took a 2.5-hour literacy test in Alabama to qualify to vote. You had the literacy test, the grandfather clause, the white primaries, and poll taxes. It was 1960. I had to interpret the due process clause of the 14th Amendment. Now, my daddy couldn't read and write. He never was able to qualify to vote. So and we're still now fighting, as I call the evolution of the circle, in this twilight zone, because just last year the Supreme Court nullified Section 4 of the 1965 Voter Rights Act, which nullified Section 5, which is a preclearance. So that all of the laws that have been passed to try to confer on us human status and citizenship have not worked. So in 2015, we're still fighting, except for the fact we stopped fighting, we stopped protesting. I mean, we've always fought, as you know, and now we've seen as if we think we're free. We don't fight anymore, we don't challenge anymore, we don't confront anymore, we don't boycott anymore. We've become a member of the family. Go into the big corporations and they have this game, and I'm not going to talk too long. If you want one, you send one to get one. But one day when you send one to get one, the one they send one to get will be you. Because what goes around, okay. That's basically, unless you have some specific questions about the legal basis for black people attempting to make them human first. That's why I don't tolerate anyone who said, our movement is just like the civil rights movement. It is not. We first had to overcome being non-human and then go for rights. I will have some recommendations about how we solve those problems in 2015, 2014, 2016. Has something to do with a 4-letter word. Can I use a 4-letter word here? Yeah, vote. Go ahead.
Dr. Anya, you're a different generation from these 3 old people here. And 2 of these 3 old people grew up in the South. And so I would imagine that you would bring a fresh perspective to 2 issues. One, of course, is how do you view the 13th Amendment? What is your perspective as a younger person on the 13th Amendment? And secondly, are there strategies that you think that African Americans can employ to fully realize the vision of the original 13th Amendment? I'm thinking specifically of the section in the Supreme Court decision which talked about badges and incidences of servitude as a way of understanding not only the implications of the 13th Amendment for freedom for African Americans, but also the ways in which the 13th Amendment might be understood as a civil rights tool to gain greater equality in society.
That's an excellent question. I first want to thank the DuSable Museum for hosting this critical discussion. I'm also honored to share the stage with these three older gentlemen. We can never underestimate the value of historical context, and personally, being able to share the stage with individuals who have that knowledge, that institutional knowledge, is invaluable. And so it's an honor to share the stage with you and perhaps lend a little bit of my perspective on the 13th Amendment, as well as the attendant amendments and how they relate to what we're experiencing today. So for the first part of your question, in terms of a perspective on the effect or the perception of the 13th Amendment today, I think it's easy for us to become disconnected from what it means. And so there are two things that I want to highlight, one of them being the messiness of process. And this goes toward the legal ramifications of getting the 13th Amendment passed, what that took. The second point is to timing and how long this process took. And then the third point, we'll get to the last question in terms of breaking down the language in the 13th Amendment and some of the implications for today. So the first point about messiness, when we learned in elementary school, I believe, about the 13th Amendment, we had a fairly one-dimensional education on it. So it was seen as we had Abraham Lincoln, who, out of the benevolence of his heart, decided that we needed to free the slaves. And so he had a couple of conversations, and then on that one great day, it happened and everyone was free. That's pretty much the story from, at least when I was in elementary school. That's what we get. And so that story does not do justice to the complicated nature of what it means to pass an amendment that is about, first and foremost, guaranteeing humanity that was afforded to everyone else except black people in this country. And so Attorney Todd is correct in that what it meant was establishing our basic humanity. And so that does differentiate us from the experiences that we have today, which is more about how do we refine that basic premise so that we are guaranteed the full rights as our citizens who have not gone through the experience that we have as African Americans in this country. And so we have to understand how complicated it was, that it in fact did not pass the House the first time. It passed the Senate, it didn't pass the House. That it was political, that it was not a benevolent act by an enlightened human being who saw the need to free people. It was more about politics, that it only passed Congress when an election was coming up. And that underscores the fact that Attorney Todd brought up again about the four-letter word that we should be taking very seriously. And so right before an election is when Congress was able to take that next step to actually get it passed. And so we need to understand that complicated process, that even after the 13th Amendment, it didn't guarantee anything. It was necessary to have the 14th and the 15th Amendment to, again, begin to refine the basic premise that black people are human beings in this country. And when you appreciate the messiness of the process, I think it helps us to look at the current context of what we're dealing with as African Americans in this country and really be able to contend with the forces that still seek to dehumanize black people in this country. And so that's a point that I want to bring up. The second point is about timing and the fact that last year, the Voting Rights Act was essentially gutted. 40 years this year in 2015? 40 years after passage? And so imagine when they were initially talking about the 13th Amendment, how many generations that took. For us to fast forward to today, where we are seeing the rollback of all of the gains that have been made in a very, very short amount of time. And I think we really have to understand that, because younger generations, if we're not careful and we don't understand, number one, the complicated nature of how these laws are passed, how these amendments were passed, when we don't understand the messiness of it, when we don't understand the work that it took, and the need for sustained effort, in a very short amount of time, we can see those gains beginning to be rolled back, which they have, and they continue to be as of last year. And so the timing factor, I think, is critical if we're to understand the importance of the 13th Amendment in the current context. And then the last piece that I want to sort of highlight is, I think it's very relevant, especially for younger generations, as we're looking at what happens with the prison industrial complex and this notion of servitude. And I just want to call attention to the 13th Amendment, where it says that neither slavery nor involuntary servitude, except as a punishment for crime, wherever the parties shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Neither slavery nor involuntary servitude, except as a punishment for crime. And so I'm bringing that up because we're faced with a crisis in this country, the prison industrial complex. Whereas the 13th Amendment was supposedly guaranteeing us our basic humanity, and yet we see that it has been stripped from an entire generation, and in fact generations of African American and Latino men and women in this country. So they have not, because they have committed a crime, then the servitude is acceptable, according to the 13th Amendment. And so we really need to take a critical look at what happened when we're not vigilant. So we know that our justice system is not fair. We know that there is a disproportionate impact on Black and Latino men in this country. We know that in sentencing, the disparities in sentencing have essentially guaranteed an entire generation that is going to prison. We know that they are building prisons according to your reading level at the 3rd grade. We know that they have quotas according to a food contract to determine the size of the prison. And so when you're falling below the quota, what does that mean? It means you have to arrest people. What do we know that our inmates do when they're there? How do our license plates get made? What are the products that are being sold in the economy that are made, generated through the prison system? That is servitude. What do we know when we understand the connection between the disparate sentencing and an unfair criminal justice system that, according to this 13th Amendment, makes servitude acceptable? So we have a pipeline of these very same Black people going into the prison system where servitude is now acceptable because we don't call it slavery, but it's the same system. So I want to bring that up as part of the conversation when we're reflecting on the 13th Amendment and when we're thinking about it from the perspective of those of us who are perhaps younger, who have been following what's been happening nationally with how we are treated by the police, with how we are treated by a justice system that still does not see Black and Latino lives as important. And are we really free when an entire generation is locked up, unable to care for their families, taken out of their homes? Are we really free? Is the 13th Amendment serving us? And so I'll wrap it up by bringing it back to the need for sustained action, the need for sustained pressure on a system that was never designed for us. It was never designed for us to grow and thrive. We've had to fight from the very beginning. And so it is especially important that now, as we are, especially this generation, understanding the historical context of what the 13th Amendment meant, the 14th and 15th Amendment, and the need to fight for those gains, but also even more so the need to sustain that pressure to make sure that we have individuals who are influencing that system, who are the attorneys, who are the lawyers, who can push back to make sure that what we are guaranteed by the fact that we are born, we get. We only get that through a fight. And so I'm hoping that that is the line of thinking as we're examining what the 13th Amendment can mean today and how it's relevant today. Thank you.
I've devoted a lot of my life to DuSable Museum, and I learned DuSable at the knee of Dr. Margaret Burroughs. And the first lesson was that the audience must be involved as early as possible because we are a family. We are a community, and we always want to hear your voices. While you're organizing your questions and beginning to line up, let us remind ourselves of a couple of things. One relating to Professor Reed's presentation. Keep in mind that in 1860, 15 of 33 states had slavery. Keep in mind that there were earlier 13th Amendments, one that was floating around for a long period of time having something to do with stripping people of their citizenship if they accepted a foreign title. There has never been a period of time in American history where there was a longer distance between the ratification of a new amendment than between the 12th and the 13th Amendment. Keep in mind what Professor Reed also remarked to you, that there were two other proposed 13th Amendment, the Crittenden Compromise and the Corwin Amendments. Both would have kept slavery in their place, both rejected by Abraham Lincoln. Perhaps the Civil War might not have occurred if he'd accepted or supported either of those amendments. The reason Ohio voted in favor of the Corwin Amendment was because they were desperate to prevent a war. Keep in mind also that Thaddeus Stevens and Charles Fremont proposed an amendment that read this way: all persons are equal before the law. Notice that that is not in the 13th Amendment that was ultimately adopted. The 13th Amendment that ultimately adopted sounded more like the prohibition on slavery in the Northwest Ordinance. Finally, one more point. How many of you know the Yellow Dog Blues? Raise your hands. How many of you know the Yellow Dog Blues? There are no W.C. Handy fans here. How many of you know who W.C. Handy is? The father of the blues. What's the bridge for the Yellow Dog Blues? Going where the yeller meet the dog. What does that mean? What that means is in the 1890s, you began to see, beginning with Mississippi, because it always begins with Mississippi, the introduction of something called the pig laws. Historians know about the pig laws. Basically, it said if you stole a pig, if you saw any animal valued at $10 or more, then you committed a felony. Within a few years, the number of African-American males in prison grew by 10 times. This relates to Dr. Emiya's point about the criminalization of behavior as a way of creating a new slavery. Back to the Yellow Dog Blues. The yeller, the dog refers to the dog leg in front of Parchment Farm. Anybody here know what Parchment Farm is? It's the biggest prison in Mississippi. The yeller is the color of the train that passed in front of Parchment Farm. No explanation in this song, yet millions of African Americans made it a hit because it meant I'm going where I'm going to finally be released from prison. I'm going to where I can finally be free. Since the topic under discussion today is freedom and the 13th Amendment, remember, and this is the point that I think was excellently made by Dr. Emiya, is that freedom has to be jealously guarded because there are new and insidious techniques being employed to deny African Americans freedom under the guise of criminalization. So we eagerly await your questions.
Let me just say this, though. W.E.B. Du Bois said in 1903, and so black folks, that in the South, prisons will be used to re-enslave blacks. And how does that relate to today? The 101 ratio between crack cocaine and powdered cocaine, introduced by Herbert Walker Bush, reauthorized by Clinton, led by Janet Reno, led by Eric Holder. 100% ratio. They knew that crack cocaine basically sold by young black and Latino men, and also that the powder cocaine was used by basically wealthy white people. So it hasn't changed. But when we get back into it, where did he go? Because I want to give you some legal framework and tell you the problem that we are having now with our trained lawyers and people who are more concerned about what's in their 401k than they are about the KKK. Did y'all write that down? Go ahead.
Okay, we'll begin our questions at this point.
Any questions for the panelists, ladies and gentlemen? Please make your way down towards the microphone, please. We have one on either side.
Darrell Allen, Oak Park, Illinois. My question is this. When individuals in schools are having difficulty with just attendance, how do we get these difficult and tough topics into the minds of those individuals who are going to be impacted by missing the education and understanding that they are actually under siege?
Well,
Are you directing that to any one particular profession?
All of you on the stage.
yeah, you know, one of the things I've experienced is working with Boys and Girls Clubs of Chicago, especially Dr. King on the west side, and I found small group settings are best for teaching what we're talking about. You can have 30 people in the classroom, 20 may be awake, 10 might want to be there, but in the small group, I think you have a better chance in getting messages across. So briefly, my solution is Mr. and Mrs. Jones with their kids and 7, 8 neighbors started off, or such and such church starts off something. Start small, build big. That's my solution.
Thank you.
Go ahead.
I think this kind of education has to be infused across the board. It can't take place just within the classroom, so which supports the previous point, that it does have to happen in all of our institutions, starting in the home, but also in the churches, the places where we typically have used to impart knowledge. I think that's absolutely critical. From an education system standpoint, I think this just highlights the importance of having a curriculum that is well-rounded and honest, and a curriculum that is driven by the truth. And so even in our Chicago public schools, we had an African-American curriculum. There was a law on the books for years. It was simply never enforced. And so we did not have it in the schools. And I think that we have to, again, put pressure to make sure that we have the kind of curriculum that teaches history in the classroom. But it can't replace what we're supposed to get in those other informal institutions through our neighborhoods, through our churches, and through our families.
Thank you.
Now, I'm a product of all black schools. I like to say from Sunday school to law school. I went to an all-black law school, and all of the schools I went to, I never had a white teacher. I never had a white fellow classmate or what have you. It was all black. What the difference was when I came to Chicago and taught at Northwestern and saw what was going on is that in the deep segregated South, we valued education. We saw a relationship between getting the education and a way out of the mess that we were living in. And although they segregated the schools with no resources for the most part, we knew that if we got the education, we knew if we learned 1 + 1 = 2 in that segregated school, then we knew that we would know 1 + 1 = 2 all over the world. Now, you start in the home. My mother had a 2nd grade education. My father couldn't read and write at all. But my obligation was to go to school, and I had to go to school. And they insisted that I go to school. And for those persons who said that the parents don't care in Chicago and what have you, give them a basketball. Give them a sport, a football, and you will see them shooting hoops 24/7. Because what has happened is that in many instances, the parents are the first teachers, but they're not the best teachers. Now listen to me, because I've seen it happen over and over again. They would rather, and I do a little speaking every now and then, they would rather teach their sons to rap before they teach them to read, and teach their daughters to wiggle before they teach them to write. Why? Because, well, no, hear me. There's an association between these things and America's God. What's America's God?
Money.
Money's America's God.
Some money.
And so as a result of that, they spend so much time. Why is it that you see almost every day some mother fighting somebody over $250 Jordans? Because they see a value in that. We've got to go back to teaching the value, not just inside the classroom, because you're going to deal with charters and Common Core and all of that, but in the churches and in the homes, and for those of us who got a little education, to teach those who don't have it. It takes a village to raise a child, the West African proverb is, but it takes an entire community to save one. And so we need to go back to what worked for us in the South and what worked for us at one time in Alabama. And don't be intimidated by this dude with yellow dog. He's from Memphis. So he was raised on W.C. Handy.
I was raised, WVON, I was raised on it. Can I take a different perspective?
Yeah, go.
Let me take a more historical perspective. I just gave you a little bit of the run-up to the 13th Amendment because I didn't want to obviously cover the same ground that Professor Reed covered so admirably. But it does seem to me that a little historical understanding of the post-13th Amendment, the post-Reconstruction period is useful here. We know that the last legs of Reconstruction featured the passage of a Civil Rights Act. And we also know that that Civil Rights Act of 1875 was declared unconstitutional in 1883 by the Supreme Court. The importance of this cannot be overstated. In the first place, there may have been non-racial factors at play. Many felt that Abraham Lincoln had overstepped the power of the executive branch and impinged on the power of the judicial branch, so they were trying to keep the balance up. Nevertheless, trying not to cast aspersions on the motives of the justices, one thing is very clear, and that is that the Supreme Court played a very important role in attempting to eviscerate protections for African Americans in the South under the 13th and 14th Amendment, and they were more effective in undermining the 14th than the 13th Amendment, which is why I think the 13th Amendment discussion is so important. And what they did, and if you read John Marshall Harlan's dissent, it becomes very clear that he was the through line for understanding the significance of the 13th Amendment. What they did was say, okay, anything that would re-enslave an African American is bad, but you can make distinctions, and these distinctions will not be viewed as discriminatory. And of course, in this logic in Cruikshank and then ultimately in Brown, we see the evolution of this argument, which ultimately would give support to the idea that something called separate but equal was even possible. So what I'm suggesting to you is not something that is archaic and covered with cobwebs and oh so 19th century. What I'm suggesting to you is something that's very important in terms of recent Supreme Court decisions undermining the Section 5 provisions of the 14th Amendment and undermining the idea that the Commerce Clause can be used to protect civil rights. What we're seeing very recently in present discussions is whether or not there can be discrimination that is permissible as long as it's not intentionally based on race, which seems to me to be an obfuscation. What we're beginning to understand is that the composition of the court is critical. The Supreme Court in the 1960s expanded our understanding of the 13th Amendment. The Supreme Court in the 1970s, as early as the 1970s, began chipping away, and of course, we have decisions in, 96 and 2000, which were even more important in terms of undermining 14th Amendment protections. What the 13th Amendment can do is not simply protect you from state action, but from the actions of other individuals. And a Supreme Court composed of individuals who read a little bit of history, I'm not asking them to read a lot of it, I'm asking them to read a little bit of history, will understand the significance of the earlier Supreme Court decisions which said that badges and incidences of servitude fall under the 13th Amendment. And as John Marshall Harlan, remember John Marshall Harlan is writing in the 1880s. This is before before Plessy. If a white man can do it and a black man cannot do it, that is an example of badges and incidences of servitude, because slavery is built on the assumption of the inherent inferiority of black people. So anything that reflects the inherent inferiority of black people is a violation of the 13th Amendment. Some contemporary jurist who's willing to read Harlan seriously and willing to expand our understanding and interpretation of the 13th Amendment might be able to craft it into a useful tool. Well, how do we do this?
Like Clarence Thomas?
How do we do this?
No,
I don't think Clarence Thomas is going to reread the 13th Amendment. How do we do this? The way we do this is vote.
Let me just piggyback. May I just piggyback for a moment?
Well,
Go ahead.
we got these people.
Yeah, but I'm answering the question that you answered to the question that she asked. He asked. But go ahead.
Let's let her ask a question, and then we'll certainly let you respond.
No problem.
Any way you want.
Go ahead, ma'am. I'm sorry. Yes.
Please ask your question or make your comment.
Please.
Okay, good afternoon.
Good afternoon.
My name is Hunter Adams III, and I've had the pleasure and privilege of working with the DuSable and the Amistad Commission on the African American Interdisciplinary Curriculum Project and other projects for the past couple of years. In one of my presentations, one of the things that I suggested, and I'm so happy that this is happening today, is that we've never had a discussion of what, according to the 14th Amendment, citizenship really is. What are the constraints of this citizenship? If I moved to Sweden and in 10 years became a citizen of Sweden, then I would have the rights, ostensibly, as all Swedish people do. If someone from Sweden or somewhere else in Europe come here, they would have all the rights, allegedly, according to what the Constitution says citizenship is. But for people of African descent, the problem is, for us, citizenship has never really, truly been defined or protected. What I would like to know, and maybe one of the illustrious people there can help a brother out, were there any debates and discussions, notes on the 13th, 14th, 15th Amendment in the states? I mean, I'm curious to learn what was the conversations that was taking place in the states regarding those amendments, because I think that may give us some insights into how to move forward, because I really see that we have to have this discussion. Ferguson really shows us how fees and fines, also in Chicago, are used as a form of taxes and revenue for cities and to constantly oppress the black population. We, in fact, pay our taxes to be plundered by the state governments and by the federal government. But we get nothing in return for that except the erosion of the rights that we think we really had. So I'll just kind of leave it at that.
Would anybody like to respond to that? I'll make one important point, and that is you must understand the significance of the 14th Amendment in overturning Dred Scott. Remember, after Dred Scott, African Americans not only had no rights which white men were bound to respect, but we were not, by Supreme Court determination, citizens of the United States.
Right.
Without the 14th, because the 13th Amendment only ended slavery, and the 15th Amendment gave African American males, remember, not African American women, only African American males, and not white women, the right to vote. So it's the 14th Amendment, which is a direct response to Dred Scott, which grants citizenship. And basically the discussion is not about granting African Americans the right to vote, because as Professor Reed made very clear, this is a state province, but rather it is about whether or not African Americans can be protected in their civil rights, and the foundation for that is to grant them citizenship.
Taney's decision has never been overturned, nullified.
A constitutional amendment overturns a Supreme Court decision.
Okay.
Or takes precedent, is more important than a Supreme Court decision.
Well, let me just respond to that for a moment, because absolutely, my position is whether, even with the 14th Amendment, that Dred Scott lives, because
Right.
of the subtle kind of problems dealing with the belief of the inherent inferiority. Let me take a different tack on that. Not what they debated, it's what we failed to do. We took the education, we got the law degrees, we got the accounting degrees, and we decided to go after the money. Thurgood Marshall and Charlie Houston and James Nabret litigated from 1938 up until 1954 for Brown. Thurgood Marshall died poor. He didn't go after the corporate dollars. They used the education to bring along the persons behind them. We started with Missouri ex-rel Gaines versus Canada, Lawton versus Oklahoma, ended up with Sweat versus Peonage in 1947, and then ended up with Brown versus Board of Education in 1954. They litigated all this time. What we've done now is that the tools are there, my brother, and we can look at the history of the 1866 Civil Rights Act. But we've got the tools now under the 13th Amendment. 42 USC 1981, y'all write this down, 42 USC 1983, 18 USC 242, 18 USC 241. These are all statutes that were passed under the 13th Amendment in 1866 we don't use anymore. You absolutely have a right under the 13th Amendment under 1983 to sue for damages in the federal court, not in the state courts. But we don't use these weapons anymore because we're too busy dealing with the corporate structure and making money. So as a result of that, we have fallen behind because we don't litigate anymore. We don't boycott anymore. We don't march anymore. Even in China, they're marching, singing, "We shall overcome." And we are in this country saying that marching is passé. And we will ride. So if you look at the legislative history of the 1866 Civil Rights Act,
Okay.
especially that one, you will find a lot of the material that you're talking about in the debate. Okay?
Thank you. Thank you very much.
Let's give more people a chance to talk.
Hi, Maisha Hamilton Bennett. I wanted to look at the 13th Amendment in the context of two things. One is Somerset. Somerset was a case in the 1700s that said that slavery, it was in, a white person had taken a black person to England and held him in slavery. And, these guardians came forward to try to liberate this man because they say he cannot be a slave in England. And the courts there ruled that slavery cannot exist without positive law. There has to be a law that says it's okay to exist, otherwise it can't exist. And I would maintain that the 13th Amendment created positive law for slavery in this country because it gave, the exception clause says slavery can exist in this country if you've been duly convicted of crime. And duly convicted was never, duly convicted was if the state says you're guilty, you're guilty. The same thing that happened with Tillman, the young boy who was said he whistled at a white woman. They said, "Oh yeah,
Emmett Till.
Emmett Till, sorry. If she says you whistle, then you whistle. You know, so due process never existed, has never existed in this country. And so I would like to say, in the context of the United Nations, which says that slavery is a crime against humanity, how do we justify an amendment that is positive law for slavery? How can something be legal in this country, which is unlawful in the world? I'd like somebody to respond to that because it seems to me like Charles Sumner's amendment, which was that all men are equal before the law, was probably the only way to go because white people in this country are individuals. Black people are members of a group, of a despised group, of a looked down upon group. And so I think we have to move beyond the 13th. I think the 13th Amendment person needs to be repealed and replaced with Charles Sumner's amendment, all men and women are equal before the law. So how do you reconcile, you on the panel, the 13th Amendment with the United Nations Declaration that slavery shall not exist in this world because it is a crime against humanity?
Dr. Anya?
Yes. So in the context of international law, I think the dilemma is that in the United States, we tend to pick and choose those laws that we're willing to abide by. And so if in the international, in the United Nations, if they've said that slavery it cannot exist, but if we decide that that's not what we're going to abide by, then it doesn't affect us, or we're not going to abide by it.
We signed it.
And
The United States signed it.
so my point being that the United Nations, even as an entity, was something that you enter into, but it's not always binding for the United States. And so if it's something that's going to interfere with our interests, if we wanted to harbor slaves, then we were going to harbor slaves, even as we pick and choose what aspects of the United Nations we're able to abide by. And that's historically been the case. And so I think that's why, even as we had a group from Chicago called We Charge Genocide that went to the United Nations to talk about this issue of police brutality in our communities. And it was done intentionally to highlight the fact that when everyone else, when all of these other countries in the world are moving forward in terms of how they see policing and community policing and interactions with citizens, here in Chicago, we're doing something else. And so what it does is it puts, I think, a normative pressure on the United States to encourage us to evolve in terms of how we see what it is we're doing, whether it's in police brutality, whether it's how we see slavery, or what have you. But I think the weak part of international law with the United Nations has always been that we don't necessarily abide by the law if it's not according to our interests.
Okay, next.
Well, let me just respond to that for one second. The United Nations is a law of nations. The United States of America would have to take that case. They won't go. They won't, the federal government, led by whatever, I don't remember the president's name now, but they would have to go to the United Nations, and this country has not signed the anti-lynch statute. Secondly, the only enforcement that the United Nations has is consent or war.
Exactly.
And the United States pays how much of the United Nations budget? That's the end of that.
Yep.
That's not fun. You're absolutely right, but this country is not going to go in front of the United Nations and hold itself up. It's just not going to do it.
Welcome.
Now, if I'm elected president of the United States, go ahead.
That would be a good job. Please.
I would like to, my name's Kiana Wiseman Fuselier. I'm visiting here from Houston, Texas, and I do apologize for the bushes. Okay.
The Bushes.
You know, those people. And Rick Perry. But my concern is I have 3 nephews who have been a part of the entrapment and the continual revolving door that occurs when a young man is caught for whatever reason and becomes a quote-unquote felon. And when they get out, there was a time when I was a child that I was taught, well, he's paid his debt to society. Well, that doesn't happen anymore. It's a revolving door, and I keep sending them books, and they get out, and they're free for a while, and they go and they look for a job. But everywhere they go, it's a constant case of you have to check that box, and then they go find someone else. And then the perpetuation and the proliferation of tattoos and the gold teeth and the yada, 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 and the habits that they learn in prison brings them back to where they were. And the system is set up to keep them there, because once they get in, when they get out, it is hard for them to rejoin society because of the fact of the barriers that are placed for them. And traditionally, these are young black men. And unfortunately, this is a cycle that too many of the images that they get on television, the perpetuation of people like Snoop Dogg and whatever other kind of animals are out there, just perpetuate this. What can we do to improve the laws that help us to help our young men grow up and become functional members of our society once again when so much is stacked against them?
Any other panel?
Oh, yeah, no, I always have something to say. What has happened over and over again is that, and I was a federal prosecutor for 3 years, but the prosecutor's office was not a stepping stone for politics. What we've got to do, and I've made a joke about the 4-letter word, but what we've got to do now is, you've got 40-some-odd members of the Congressional Black Caucus, and yet when they dealt with the 100-to-1 ratio and what have you, nobody said anything. You've got all of these state legislators in Houston, you've got Sheila Jackson Lee, you've got Texas Southern right there in the 7th Ward.
The Thurgood
You've-
Marshall
Third
School
Ward,
of
you're
Law.
at Prairie View. But you see, what we have had, our problem, and it's very hard for us to accept, is that many of the people we've elected and most of the people we put in office, they're carrying the same water against our kids as the persons that they have joined. And we keep returning them. We keep voting for them. You talk about Parchman in Mississippi, but Huntsville in Texas is the same thing. Atmore in Alabama, Angola in Louisiana. It's the same thing.
yes.
But where are our black politicians who are supposed to be protecting the black community?
They're protecting their office.
They're protecting their office and they're protecting their party affiliations.
I
In 1990, let me just say, 92, the Pell Grant was taken out of prisons so that mostly blacks, so that prisoners were unable to get money from the federal government to study to get something that they could use once they get out. Who did that? Who did it? It was done under Clinton.
Please tell me that's not
Yes,
true.
it's true. I was working with Talladega College. They lost 100 students in the Talladega Federal Correction Center because they lost a Pell Grant. So we've got to stop dealing with parties and stop dealing with persons and protect black people who are still not free. I mean, I know that's the race card, but it's happening to us over and over again. As a federal prosecutor, I went into homes. I went into the homes of people because I was concerned about them. But I know that if you get that brick once, and then the second time you're picked up even on a traffic violation, it multiplies.
Exactly.
But why haven't we introduced legislation that fought to eliminate that? We haven't done it.
Okay, we need to let more people
I'm sorry.
talk. No. That's
I'm
quite
through. I'm
we
not
need-
saying anything today.
Well, no, he's not through, I guarantee you. Please, welcome, and please ask your question.
Thank you. Good afternoon, ladies and gentlemen. I'd like to piggyback on what she said.
Speak just a tad louder.
I'd like to piggyback on what she said. I'm commenting, I'm not questioning. Make the point that the media was very complacent in the dehumanization and the constant stereotypes of young black men, and which in the way that they are perceived in the eye of the public, and constantly, discredited, and often looked at as a threat to civility, But my comment is, I think that we're questioning where we've come from slavery, and how much freedoms have we gained, and how many strides towards being this citizen of the United States have we made, seeing as how we've been often have obstacles put in our way. How far have we come? But I just wanted to challenge people to, on this 50th anniversary of the assassination of Malcolm X, challenge people to think about separatism and nationalism, because we're special people. We are the only people here who came against our will. Everyone else came via boat, via plane, some cross borders to come here to find a better life for themselves, but we were the only people brought here beneath boats, chained and shackled, and we're a special people, and our identity here and our presence here is something that it itches the very fabric of where this country was founded, and also a lot of the inhabitants. But we should question not how we can become free, but how we can become sovereign. One reason why China doesn't have to vote and participate in any elections, nor do they fill our prison system, is because they have sovereignty. We owe China a lot of money. American debt to China is very high. And they have what's called sovereignty, where they can have diplomatic relations with the United States. And it's not a question of begging for some type of human right, but more so the constant awareness that we are a sovereign nation who are capable of defending themselves. Black people in this country are defenseless. We come and we beg for jobs. We've had this mentality since slavery. Hey, send your child to a good school so they can go get a good job. And these good jobs and these
Excuse me, 10 seconds to complete your
good
comment
schools
or question, sir.
are often white. So we inbred. I mean, children learn early what racism is and how valuable their skin color is and how important they are. So when we tell them to go to a good school to get a good job, and we don't see black professionals in the light, the media doesn't really shine a broad light on black success stories, a lot from the young urban youth. Why are we still constantly beating the drum for freedom when we should be trying to be more self-sufficient and be able to come together with all of the great potential of education and wealth that we've accumulated as surviving this catastrophe
Excuse
to
me.
try and become
Thank you. In the
something
interest
more
of time, we
Thank
just
you
want
very
to
much.
thank you very
Very
much,
well
sir.
said.
Thank you.
I wanted to briefly respond to that comment to make sure that we don't necessarily conflate the prolonged struggle for rights in this country, in this context, with self-sufficiency. I see the two things as not mutually exclusive. I think self-sufficiency is key, it is critical. That means that we have to have an agenda, we have to have a plan, we have to have conscious leadership that is willing to advance that agenda, and that's something that we unfortunately haven't had as much as we should. But I think that the struggle exists across the board. Even in a homogenous society, if there ever was one, even in a single race society, there would be the need for struggle. I think that's standard. Even in societies, I mean, we have in different countries where you're all the same race, but divisions based on class. There's always going to be the need for struggle in any society, which means that the ability to have tools to fight that struggle is so important. And so that comes back to this question of education. And we talk about education to get a job, education to get into college, but we rarely talk about education for empowerment. And so someone like myself, every degree that I got was a tool, because I know the society that I live in. And so if you're interested in affecting change, or if you're interested in dismantling or transforming a system that is not working for us, what tools do you have in your toolbox? It has to be the law. How do we use the law to advance an agenda that actually works for our people? And so that is going to be necessary whether we're in a single race society or in the United States. It doesn't mean that self-sufficiency is not important. That goes without saying. I think that's a given. But the question that we need to be asking ourselves is, how do we cultivate conscious leadership that actually is equipped with the tools to advance an agenda that will transform a system into one that more closely resembles what we deserve?
Thank you. Philip, welcome, and please ask your question or make your comment.
Thank you. I just want to take a minute to really thank everybody here. I'm on the Amistad Commission. That's a commission that is in the state of Illinois that is commissioned to do education around slavery and the African slave trade. And I just want to thank the DuSable for partnering with us on this. And this is a great, outstanding program. I also want to acknowledge Senator Bill Shaw and Mello Sam. Back in 1991, they helped to get a law passed that a unit of African American history must be taught in every school in the state of Illinois. And probably up until today, that is a law that is not being followed. So I have two juxtaposing concepts. One are formal systems of racial control that are historical and even active now, starting with slavery, peonage, contract leasing, the black codes, Jim Crow, mass incarceration, and possibly the most insidious form of racial control, inferior public education. And so that's on one end. And then on the other hand, we've got wonderful legislation. The 13th Amendment, the 14th, the 15th, Brown versus Board of Education. Those are great pieces of legislation. And then I look at where we are today. And so the legislation seems to be illusory. It's almost like, it's a distraction. It's to keep us busy while these other serious forms of racial control are at work directing us as a people. And so, my question to you is, these forms of racial control, they seem to outweigh any legislation, including the 13th Amendment, including Brown v. Board, anything that's coming down the pike. What are the solutions to that, if that is a problem?
Yeah, how about if Brother Malcolm were alive today, he'd say that 4-letter word vote is important, but a 5-letter word power. You mentioned empowerment. You need to acquire power, so you don't have to ask for things. You don't have to demand things. You will command respect and get what you want. Would you believe in certain districts of this city, the police know what they can and can't do and will not harass kids? Why? Because those communities have what? They have power. It's as simple as that. We never talk. That's the word we're afraid of. Power. And you should be afraid of it. In fact, when I think of Mississippi, the first thing I think of is why the people suffered so much after a certain time, because they dared to what? Assume power with weapons, with economic clout, with political clout after the Civil War. And then they were, as the Panthers used to say, vamped on, about 100-some years ago. But people from Mississippi were fighting, are still fighting, still progressing. It's power, and we don't even talk about that. Nothing against the law as a means to get things done, nothing against education, and I think about Carter G. Woodson and the miseducation. And Brother Jackson, you know yourself, the law that's passed to have a unit on African American history, it's like the unit on Holocaust history. Neither one was taught. Then, of course, you need people who know how to teach it. Yeah. Find out what power's about. Find out how you can get power. In fact, this institution here is an example from the man of Charles and Margaret Burroughs of what can be done with the acquisition of power. You can speak your mind at DuSable, one of the few places you can speak it. So that's all I wanted to say, that 5-letter word. She mentioned empowerment, power. Start thinking about how you can control your own life, the life of your family, your neighborhood's life, your community's life. And boy, don't I wish Harold Washington were alive that I could vote for him. I'm going to think about that on election day.
Welcome. We're glad to have you.
Hey, how you doing? Hi, everyone. My name is Sydney Hinton, and I'm a recent graduate of Northeastern Illinois University. And just recently, I got an email saying the mayor may be trying to cut the public universities funding MAP grant by 31%. And when we bring that back to education being freedom and power, that's just one thing I think of, what students are going to be affected, and especially what population, Black, low income, those type of people. And what they did was they sent us the notice 2 days before we had to apply for FAFSA before we would get cut off that list. Luckily, I graduated, but I think about my peers who, in the middle of spring, and this is midterms, you're probably not even checking your email, you won't get funding for next fall. So, okay, I just want to put that out there. But secondly, I wanted to ask a question as it pertains to freedom and just embracing our rights and liberties. I want to say, I think right now, one issue we have to address is the intergenerational disconnect, because I feel like this generation definitely feels free, and it's not a sense of maybe physical freedom, but maybe spiritual. So when you see things like Black Lives Matter, this generation definitely feels free, and I think older generations feel well, we're not free yet, and this is why. And I'm feeling to them, they're free. And then if you say something well, you're not free because you can do drugs or because you could do anything you want to do and make whatever decision you feel like you need to make or want to make because that's just you, to them that's freedom. It's then they're saying you're using respectability politics against them. So what I'm asking you now is, what types of techniques do you think we can use to engage younger and older generations in understanding the true notion of freedom? And how can we do that without shaming or degrading one another? In a sense that, how can we do this so that we uplift, so that we make each other feel okay, your definition is cool, our definition is this, but look, this is where we meet, this is how we interact, and this is how we can unite.
I think that's an excellent question. It has to do with intergenerational communication, and so who wants to?
Well, I guess I can answer that one. I think communication, effective communication across generations begins with respecting where we are. As a person from the younger generation, respecting where I am, but also being able to respect my elders and respect what they've done. And vice versa, meaning the older generation being able to respect that there is a need for new ideas, new methods, new ways of thinking, new ways of perceiving how we fight this sustained struggle, because the issues tend to be fairly similar. And so I'm recalling, I think it was Paul, the actor, Paul Robeson. Yes.
Robeson?
Yes, he wrote a valedictorian address decades ago, and everything that he stated in that address is relevant today. So the issues that we face, they don't change drastically. At least the underpinnings are fairly consistent, but the methods that we use to address those issues or to push back against that system, I think, must change with the times. But it requires us to understand that that change is absolutely necessary. One of the challenges that we've had, especially from an organizing standpoint and in politics, when we talk about leadership, is the unwillingness to make sure that we have those new voices and those new methods that are at the table. We tend to want to replicate the same thing over and over again, and we end up getting individuals in positions of influence who do not have the right mindset. So they have what Malcolm X called, in the movie Malcolm X, the slave mind. What is the slave mind? The slave mind is the most dangerous thing because you can think that you're free and you're absolutely not. It means that you've adopted the mindset of the system that actually is destroying you. And so when we look at that next generation of leadership, how do we make sure that people like myself who are coming in with consciousness and want to make some changes, want to do things, how do we create a space for us to do that in a way that respects the path that has been blazed by those who've gone before me, but also recognizes the need for new ideas, new methods that can take us farther, because the goal at the end of the day is always to take things farther than what previous generations have done. But it requires an honest conversation. It requires us to not be afraid of each other. You cannot communicate when you're afraid of each other. And so even those who are in current leadership positions, if the fear is always, oh, they're coming after me, they're coming for my seat, they're coming for it, well, how can you effectively communicate? How can we harness that energy? And the last point that I'll make is that we have to collectively recognize that any society that does not value its younger generation, any society that does not effectively integrate the voices of young people in any and all problem solving and policy making is a society that is dying. You can look at it from any cultural context in any country around the world, in any neighborhood in this city. If we do not become much more intentional about making sure that we are grabbing those youth and grabbing those ideas and that energy that they bring to face the very real, very difficult problems that we're serving, that we're trying to solve, we will continue to see stagnation, because we'll continue to see regression, because there is no such thing as stagnation. And so that communication I think is absolutely critical for our survival.
Excuse me, panelists. Dr. Branham, one moment, please. We have 4 more questions, and those will be the last questions that we have. We're going to ask that our questionnaires please be very succinct with your question. Panelists, please be mindful of the time. We have approximately 10 minutes left for the program, so please continue with that in mind. Thank you very much.
That is correct. Please, welcome, and we'd love to have your question.
Right. I was commenting with regards to Attorney Todd's mention of the lack of litigation. With regards to Brown versus the board, we know that the student, or the proposed student who had applied to University of Maryland Law School, Donald Gaines, was denied admission based on the fact that he was black, and that set the stage for Attorney Houston and Justice Marshall to go to court and fight for Brown versus the Board of Education. Mm-hmm. My question is, why are we so underfunded when it comes to our ability to use the law to for social engineering? When I look at what Justice Marshall did, and I look at the fact that from 1935, when the Gaines case went up to basically challenge Plessy versus Ferguson, or to instantiate, okay, it's separate but equal, where's our equal law school in Maryland? And of course, that was when integration became soup du jour. My question is, if George Zimmerman can raise $500,000 in 3 weeks' time, why are we so underfunded? Why isn't everyone here a card-carrying member of the NAACP? Why don't we actually fund our cause? Why don't we? And where is the tribe of attorneys that take it for serious, that it's time to make that change, it's time for that social engineering? I'm asking you, Attorney Todd, where is my tribe?
Thank you. You have hit upon the answer in your discourse. We litigated in the South with nothing because we knew what we were doing. Absolutely. One of the greatest, and I know that some people are going to disagree with me, and I don't mind that, But one of the greatest problems that we had in this country is the brand of desegregation that was fostered on us. Now, when we were, and incidentally, the separate but equal concept came from Roberts versus City of Boston in the 1850s. Think about it, it came from the so-called northern areas because they had to have the separate schools. Plessy adopted separate but equal. But we were taught at Southern's law school, that's why I am so poor, is that you had to use your legal education to change what was going on in Alabama, Mississippi, and Georgia. And at that time, they had 5 black lawyers in Alabama. They had 3 black lawyers in Mississippi. None of them had sat for the bar. And they had 45 in Louisiana because of Southern's law school. And so the law school became the law firm for Jimmy Jones, who filed the first civil rights case in Gardner versus Louisiana from the sit-in demonstration. We knew that the legal education was to give back to the community. In desegregation, and I taught at Northwestern, you're not taught that. As a matter of fact, when students wanted to take my constitutional law course in law and racism, they laughed at them. They wanted them to take corporate law. They wanted them to take the things that make money. And we did not do a good job in bridging the historical gap to teach our young people that you can't just go for the money. You've got to use your education to make a difference. We didn't do a good job at that, and I apologize for it. When I use the 4-letter word vote, that is to get power. You're going to do what Malcolm said, the ballot or the bullet. So either you're going to get power through the ballot, or you're going to have to go ask the person you're fighting to please sell me a gun so I can shoot you. So it's easier for, unfortunately, for us to shoot each other, tragically. So I look at the vote to change not attitudes, not change what you believe in me, but to change behavior. And I look at the vote, I look at boycotting, the buck, I look at the buck, the book, and the ballot.
Thank you. Next question, please.
Yes.
Thank you for putting this event together. My name is Ramel Terry, and I have really quickly, there's a meme going around, and I found that this really resonates with today, and I think it's a huge problem with what we see, and I just want to know your thoughts about it. It says most blacks are not looking to put an end to white supremacy. They are just trying to improve their position in it. And so in that, I believe that that's very real. And another issue that I have is in Chicago, we have a very high percentage, black people have a very high percentage of voters, like about 47%. And the reality is, if we all got together, we would be unstoppable. So I definitely agree with our vote, but I believe that our position to fit within white supremacy, or position ourselves as long as we're good, we don't see that need to truly organize our vote so that we do exercise this power that we have to have people that are consciously representing us and pushing our agenda forward. So that's what I think.
Thank you.
Now, to your first question, E. Franklin Frazier, Black Bourgeoisie. Just read it.
Please,
You know what I'm
welcome, and you are our last
Actually,
question.
one more after this young lady.
Is there one
I'm
more
sorry.
after? Okay,
One more
good.
after this young lady.
Hi, I'm Madeline James. I do policy and advocacy both at the state and federal level. And I think you're absolutely right. Voting is one way to gain power. What I find also is once we voted, then we think we don't have to deal with anything after that. So it's not just voting that's important, but holding policymakers' feet to the fire. They need to be accountable. So I just saw in the Sun-Times that they're predicting this will be the lowest voter turnout in history. And even once we do vote, those of us who are registered and actually get out and vote, we will not hold our legislators' feet to the fire. And so when I hear people talk about the system, we are the system. We are either deciding to abstain from a conversation and involvement and engagement in the system, or we're engaged in the system. But we shouldn't be looking to other people to question why things are the way they are.
10 seconds, please.
We should be asking ourselves, how much are we doing about the situation.
Thank you.
Very good.
Last questions right here from Ms. Passmore.
Well, thank you for this wonderful exposure, and let's learn some more knowledge about number 13. But I am 89 years old, lived in Chicago all my life, and therefore have been entertained by Chicago. I want you all to remember, those of you who cannot have had the experience of going to the movies and seeing white men in jail and black men as trustees. Think what happened. How did that turn around? I don't want an answer. I want you to understand what happened to us. We were trusted people, people who did things and people who were good people, and we brought intelligence to our religion and to our faces. But I don't understand what's happened since then. Why is it that we now make up more of the jails, more of the business than we do of the trust of the country, so that they had white men in jail with black men being trustees? There's a lot said between that if you think about it. Many things that have been said today I want to say and have said, and one of the first things that was recommended to us was to have conversations in our homes with a few people. I do that, and you're welcome to come to my house when I have one, because it does. It does bring about a difference. You say what you want to say. Nobody's there to change the conversation or your mind. And all we want to do is hear it. And in the hearing, we come together on things. My last statement is, why don't those who are penalized, what is it called now? What's the thing now? My nephew who's sitting here with me as well, it's called something about you can't get a job after you're out. The lady just spoke about it. A felony. Why don't they get together and fight for themselves sometimes? Get a whole lot of felony people together, give them a program, have them protest.
Thank you.
One final word, and I think that you gave us a lot to think about, and that is DuSable Museum is always a place where people can come together in fellowship to listen and to speak with respect. Thank you all for coming. We appreciate your comments. We appreciate your being here. And remember, DuSable Museum is always home.